Today I'm going to speak to you about 15 and 16 of the Indian Constitution in light of right to employment and equal opportunity. If you recollect, in my previous lecture, I had discussed Article 15 of the Indian Constitution, which seeks to bring about social justice and economic welfare of various sections of society, and, and it seeks to bring about a change in the societal fabric. 15, 16, 17, and 18 need to be read together to observe the change that the constitutional makers sought to bring about in the culture and societal way of life in India. Article 16, subclause 1, ensures that there is equality of opportunity for all citizens in matters relating to employment. Article 16, subclause 2, provides that there can be no discrimination when it comes to employment on the basis of religion, race, caste, sex, descent, place of birth, or residence. Article 16, subclause 3, provides for an exception, and it allows the Parliament to make any law prescribing protection for a class or classes when it comes to employment or appointment to an office under the government or local body or authority within the state or union territory. This is the basis for domicile reservation in various job opportunities as well as in educational institutions. This is the basis for domicile reservation in various job opportunities and educational institutions. Article 16 subclause 4 and 16 subclause 5 provide for reservation in light of backward classes and also provide for protecting the right to profess a particular religion or belonging to a particular denomination. Therefore, Article 16 not only seeks to ensure protection to social minorities in the form of caste-based minorities, as well as ensures the protection of religious minorities. And Article 16, subclause 6, is not going to be discussed today, but it is another amendment that has been brought about to provide for protection to the economically weaker sections of the society. It is currently pending adjudication before the Honorable Supreme Court of India regarding its constitutional validity. Article 16 has a plethora of judgments, and therefore we are going to start with one of the first ones, which was State of Madras versus Champakam Doraijan. This was a case in 1951, whereby the State of Madras High Court. This was a case in 1951 whereby the Madras High Court had struck down the government notification which allowed reservation. And this led to the case coming up before the Supreme Court, wherein the petitioner, who belonged to the Brahmin caste, was not allowed admission in the engineering college despite having secured good marks. Eventually, the Supreme Court ruled in its favor and allowed the notification of the state government to be quashed, and this led to the first amendment to the Constitution of India, wherein this was a case where we see a clash between the fundamental rights and the directive principles of state. And the Supreme Court had observed that directive principles of state were unenforceable, whereas fundamental rights were enforceable. Hence, it was held that this particular notification would be contrary to Article 16. However, after the first constitutional amendment, there has been a specific provision to bring about reservation when it comes to educational institutions. The first constitutional amendment empowered the state to make laws specially in favor of socially backward classes. Indira Swani versus Union of India, AIR 1993, known as the first Indira Swani case, brought about an important decision when it comes to reservation. It provided for reservation only at the entry level of employment and not in terms of promotion. It put a cap on the percentage of reservation at 50%, and it led to the establishment of the Mandal Commission. Furthermore, it had observed that there was a need to bring about a special commission, and that was the National Commission for Backward Classes, to be formed to ensure equal representation of all sections of society. The Mandal Commission was constituted in 1979, and it observed that more than the majority of sections of Indian society were backward. M. Nagaraj and others versus Union of India is a 2007 judgment which has now changed the perspective regarding promotion, and it has upheld the 85th Amendment to the Constitution of India, whereby promotions also have reservation. Thus, we see a shift from the Indira Swani judgment and the jurisprudence of 1993 to 2007, wherein now reservation is not just prevalent at the entry level, however, it continues to the promotions as well. A recent case of the Supreme Court is important to discuss when it comes to reservation in light of women and providing equal opportunity of employment to women. This is a case of Secretary of Ministry of Defense versus Babita Punia. This must be read along with the subsequent judgment of March, which was before the wherein Annie Nagraj also was the Secretary of Ministry of Defense versus Babita Punia and others is an important judgment that allowed for equal opportunity to women when it comes to the armed forces. Subsequently, the decision in Annie Nagraj provided for equal opportunity to women when it comes to the Navy. It was observed by the Delhi High Court and reaffirmed by the Supreme Court that all women who were part of the armed forces at that particular juncture when this petition was filed, they would be given an opportunity to choose between whether they would be eligible for pension after 14 years of service or after 20 years of service. And this led to the formulation of the Permanent Commission for women as well as men in the armed forces. It was observed that as a one-time measure, the benefit of continuing in service until the attainment of pensionable service should also apply to all existing officers. Initially, officers were brought about for a certain period and only in certain factions of the armed forces, and they were not made permanent. However, after this judgment, there is an equality when it comes to permanent commission, be it men and women. Now let us further examine how seniority and promotion have changed course over a period of time. We see this through the various constitutional law judgments. The first being M.G. Badappanvar versus State of Karnataka. The case of M.G. Badappanvar versus State of Karnataka saw how the Supreme Court ensured retrospective promotions to the general category people as well, and it led to a judgment wherein the petitioners were allowed arrears and a notional promotion even after having retired. This brought about a change in not just their rank and consequential benefits, but also they were given the past arrears of their emoluments. Various amendments have been brought about, sometimes to make sure that the judgments of the various amendments have been brought about to the Constitution over a period of time to ensure that there is upliftment of the various amendments have been brought about to the Constitution in light of reservation of the and providing equal opportunity to the backward classes. The 77th Amendment added Article 16, Subclause 4A to the Constitution. And the 81st Amendment added Article 16, Subclause 4B to the Constitution of India. The 85th Amendment is particularly important as it brought about reservation in promotions as well. And the 117th Amendment, which was added recently, ensured that now there is no more discrepancy with respect to who would constitute backward classes. And it was held that backward classes would be all those people where scheduled castes and scheduled tribes have been defined as per the Constitution. This ensures homogeneity in interpretation of who constitutes backward classes. Who decides adequacy of reservation? This leads us to the case of Mukesh Kumar versus State of Uttarakhand. This is an unreported judgment of the year 2020, wherein the Supreme Court has held that reservation is not a matter of absolute right, and it is the state government's prerogative to decide after having collected adequate data as to whether a person belonging to a particular region is entitled to reservation or not. Therefore, when the High Court had asked for the state government to go and find out data regarding economically and socially backward classes of people residing in that territory, this particular act of this High Court was incorrect. And it was decided by the Supreme Court that when it comes to reservation, it is the state's prerogative to notify reservation. And before one can notify reservation, one must have adequate data. Hence, if the state has not collected data with respect to people entitled to reservation in that territory, then it is not within the ambit of the court's power to direct the state to collect such data. Let us conclude this lecture by going over how 15 and 16, along with Articles 17 and 18 of the Constitution, have brought about a fundamental change in various societal customs and practices as observed in India. Article 15 and 16 have tried to ensure gender equality, social justice, as well as economic empowerment of various sections of society who have faced historic discrimination through the years. Article 17 is of fundamental importance when we speak of historic discrimination, as it abolishes untouchability, a practice that was prevalent in India prior to the independence, and it sought to bring about a discrimination in how certain sections of the society were treated based on their caste. To further bring about equality, the makers of the Constitution have ensured Article 18 leads to abolition of titles. However, titles with respect to Padma Shri and Bharat Ratna can be used. However, they cannot be used to particularly address an individual. However, titles with respect to academic titles are allowed to be used. With this, I conclude my lecture. And though at the time of making of the Constitution, reservation was seen as a means to an end to bring about upliftment of certain sections of the society, unfortunately, we observe that over a period of time, we are becoming more reliant on reservation, and we see how gradually, when there have been precedents, there have been subsequent amendments also in the Constitution, which has led to various amendments ensuring reservation, not just in educational institutions, even when it comes to promotions and seniority. In fact, when we see the first case with respect to reservation, the Indra Sani judgment, it had specifically sought to ensure that reservation is restricted only to certain vocations. However, over a period of time, we have done away with this distinction, which leads us to an important question. How successful have we been in bringing about affirmative action as being equivalent to empowerment and upliftment of various sections of the society? Thank you.